We want records from third-party business entities that their analyses of for instance, requests for loans. So these are documents that there's no privacy interest in, no constitutional liberty interest, etc. Next, we do have limiting principles. The House very much does. This court's precedent set those. Must be pertinent to a legislative purpose, can't violate constitutionally protected liberty interests or privileges, and can't undermine the president's ability to carry out his responsibilities.
Mr. Federer, let's talk about the standard you propose. The quotes in your brief is that it concern a subject on which legislation could be had. Could you give me a plausible example of a subject that you think is beyond any legislation that Congress could write?
Your Honor, I think the best I can do is refer you to the court's decision in Kilbourn, where the court there said that Congress didn't seem to put forward any possible legislation there. It had to do with bankruptcy proceedings that Congress was looking into.
Well, do you think bankruptcy proceedings is a subject on which legislation could not be had?
Obviously bankruptcy could be. But in the Kilbourn case, this court thought that no such reason had been put forward. But no, Congress's legislative authority is extremely broad, especially because of its appropriations.
Well, that's what I'm suggesting, that your test is really not much of a test. It's not a limitation. And it doesn't seem in any way to take account of the fact that we're talking about a coordinate branch of government, the executive branch. Do you have any alternative to that limitless test that would take account of the fact that you're dealing with a coordinate branch of government?